Good afternoon.
Good afternoon, Judge.
Okay, we had a little technical difficulties, but we're up and running. This is Baker versus Merrigan, or Baker versus.
Good afternoon.
Yeah, or Baker versus Blue Valley School District. It's
Okay,
case number 21CV2505.
We're up and running. This is Baker versus Merrigan,
Why is that doing
or
that?
Baker versus. Good afternoon. Yeah, or Baker versus Blue Valley School District. It's case number 21CV.
Sorry.
What did I do the other day that was doing that?
Why is that?
Do mute on your Zoom. I think, let's see if that works. Because I think that's what I did, because I kept getting over the corner.
Okay, we're back at it. Can I get appearances, please?
Please, Court, Linus L. Baker appearing on behalf of the plaintiffs.
Joe Hatley and Stephanie Levitt Bowman appearing on behalf of the defendants. Also, Melissa Hillman, School District's General Counsel, is appearing as a representative of the client.
Any other appearances? All right, proceed.
Well, Your Honor, we're here on an SB 40 petition. I have put into the record you have our petition. And the May 28th email purports to say that Blue Valley no longer has a COVID-19 policy. It evaporated or expired, they claim. And then they say that there's no policy. And then they go on to say that the following updates will begin June 1st and will continue through the 2021-22 school year. So they say that's not a policy, what I just referred to. They use the word updates. Of course, you can't update something that doesn't exist by its own definition. But then they say that masks will not be mandated, but will be highly encouraged inside Blue Valley buildings for those individuals who have not been fully vaccinated. So what they're doing is really adopting the CDC recommendations without saying so. And the phrase fully vaccinated is a term of art CDC uses. The court has adopted its own 2104 administrative order. It adopted the CDC regulations. It talks about being fully vaccinated. Fully vaccinated means 2 weeks after a person receives the second dose in a 2-dose series of the Pfizer, BioNTech, or Moderna vaccine, or 2 weeks after an individual receives a single dose of the Johnson & Johnson vaccine. That's what they must be referring to when they say fully vaccinated. That's what the CDC recommendations refer to, and that's what they're referring to. So part of the issue before the court is, of course, this claim that the policy expired. There's no board ratification of that interpretation. They have no evidence that that's the board's interpretation. They just simply say it. The August 18th, 2020 minutes adopting the navigating change didn't have a shelf life, didn't say it expired, didn't do any of those things. But okay, they say that now that went away. And now this May 28th protocol or this update, now it applies for the summer and for the coming school year. And it does indicate that the things I just said. Now, there are some things beyond this that are curious. It says, although it says masks will not be mandated, then it says masks are optional for fully vaccinated individuals. Well, what does that mean? I thought masks were going to be optional for everybody, for the fully vaccinated and not the fully vaccinated.
Let's hold up there, Mr. Baker. Let's kind of rewind here for a moment.
Sure.
What is the standing that you bring to the court to claim any injury?
Because they have a future policy that says that they've changed the policy and now we've got a new one. For a student that we are enrolled in school, this mask mandate doesn't just say there won't be mask mandated. It adds this other little jewel, which says, but will be highly encouraged.
Wait a minute. You're launching right into a criticism of what you think is a change in policy or what its provisions are. What I'm trying to get into is the injury that's at stake. SB 40 is supposed to be an emergent policy for emergencies. We're in the middle of a change where something's happened. My kid's in school, bad things are happening to them. Help me here. You got to help me because they're not doing what I want them to do. Is your kid in school right now?
It's enrolled in school, yes.
Attending school currently?
He is currently enrolled in Stillwell Elementary School and is enrolled for the 2022 school year.
Is he enrolled in a summer program or is he awaiting enrollment for the fall semester?
Well, he's not in a summer program, but he is enrolled, shows enrolled for the coming school year.
So I guess what I'm trying to figure out is what's going to be the policy of the district, whether it's mass or vaccinated. You're saying that come fall or August, whenever the kids actually go back to school, this is now going to be the district policy and this is going to harm my child when my child starts going to school. Is that pretty much it?
Not yet. No, you kind of got it, but not.
All right.
They say this
Enlighten
is
me.
okay, sure. So this policy is going to apply for the coming school year. And they say that they're going to be highly encouraging. All right, whatever that means, they will be. So you've got a parent, Terry, who has religious objections to not only the COVID-19 vaccine, but also to masks. And they say they're going to encourage her not to follow her religious beliefs. They're going to encourage her to not adhere to that because they're going to encourage her, or actually, I don't know what they're going to do, but it says will be highly encouraged. So this is a future action that they say they're going to take. And so they might as well say, we're going to highly encourage you, Terry, not to follow your religious beliefs.
So let's be clear. Terry's your wife.
Sure.
Okay. You filed a lawsuit against Blue Valley and Olathe School District. You alleged violations of equal protection. That case is now pending in federal court because you alleged a federal constitutional violation. You've now filed a second lawsuit against the same school district because you think your wife is going to be encouraged not to follow her religious belief over a suggestion by the school district that encourages the use of masks. Is that what you're telling me?
No, Judge. And all that is irrelevant. So I filed
Well, it's relevant. It's relevant to whether or not there's even an injury here.
That SB 40 says a grievance, and they've got a new policy that says what they are going to do. They say that they will not mask the mandates, but they're going to categorize certain parents and students. They say that we are going to highly encourage you, Terry, and I guess your son, to wear a mask if you're not fully vaccinated. Now you say, well, is that an emergency? Sure it is. It's COVID-19. What does COVID-19, the fully vaccinated has everything to do with COVID-19. So this is centered around COVID-19, the COVID-19 emergency. Now,
So the emergency will be when your son goes to school, not right now. Is that right?
no, the SB 40 says I have a right to grieve that policy. I have to do it within 30 days. So you can't say I don't have a right to have a grievance if the clock says within 30 days. I've done that. So that is standing. SB 40 gives the grievance standing because they grieved this policy that they say applies to the coming school year. It's a new policy. So I can't wait any longer. I can't wait beyond the 30 days, Judge, before school starts. I'll be out of luck. So I've got standing on the SB 40.
So let me make this clear then. You're not asking them to give your son an exemption because your son already has an exemption, right?
Under this policy, masks are not mandated, but they're going to categorize.
So you don't even need an exemption. You just don't have to do it if you don't want to. And your wife can tell your son, don't do it. But
there's
that's
more
harm.
to it. There's more
That's
to
a
it.
harm in what way?
That you're not saying it right. That's not what we're saying. We're saying that they're going to highly encourage who? Terry, maybe my son. And what are they going to encourage them to do? They're going to encourage them to wear a mask if they're not fully vaccinated. They shouldn't be doing that. They don't have any business encouraging Terry to not follow her religious beliefs. They don't have any business highly encouraging her to have Silas wear a mask if it interferes with his learning process. They don't have any business highly encouraging her or him if it's not healthy for Silas. So those are real things that are going on, and they promise that they're going to do it and will do it. And so I have standing under SB 40. We filed it within the 30 days of the policy. They've denied even that SB 40 applies, even though they say that this has to do with COVID-19. That has everything to do with the emergency, and that they're going to do something in the future will be highly encouraged. So I don't want Terry to be highly encouraged to not follow her religious beliefs. I don't want her to be encouraged to ask Silas to wear a mask when it interferes with his learning. He's a special needs student. They say they're going to do all those things. Now, this grievance has nothing to do with any other parent, has nothing to do with any other. If they want to put an exception in there, oh, by the way, this doesn't apply to Terry and her son, fine. But the question you have is that new policy, and it is a policy, is that narrowly tailored, and is that the least restrictive means to accomplish whatever the goal is? And I guess the goal is to hinder the spread of COVID-19, because they're saying fully vaccinated. So it has to do with COVID-19. Can it be more narrowly tailored? Sure. Sure, they can give a medical, they can give a religious, they can give a learning disability exemption. We're not going to highly encourage you folk to ask or have your son wear a mask if under those circumstances. But this is a catch-all. This is a one-size-fits-all. So what can they do when they say they're going to highly encourage? They're going to go to my son and see if they can get him to wear a mask? Are they going to try to convince Terry, hey, give up this idea about natural immunity?
Mr. Baker, after all the litigation you've initiated, do you really think anybody from the school district can approach your son or your wife and tell them they have to do anything when you've already made it abundantly clear on religious grounds or whatever grounds you don't want to wear a mask? Do you, have you even sought to communicate with the district before filing this lawsuit to say, please don't talk to my wife or my son about this? That's just yes or no.
That, Judge, that's not
answer my question. Did you?
No, I haven't. Of course
okay,
not.
thank you.
I'm in litigation.
Listen, don't interrupt me. I'm going to remove your soapbox in a minute if you just don't answer plainly. I don't want to hear a bunch of argument I simply want the facts. Now, you've filed the verification that we required in this case after the fact, and you verified the claims in your petition. Beyond that, what I want to know is if you didn't ask for an exemption or you didn't even communicate with the school district before filing this lawsuit, what is the aggrieved burden that you carry other than the fact that you don't like the fact that the policy might be suggested to other people?
Well, I disagree with your characterization, but we have a grievance.
All right.
So, and
Go
there's
go ahead and wrap your argument up.
I don't think I'm getting a fair shake here, Judge.
I'm giving you the opportunity to wrap up your argument so we can get, I mean, right now, the evidence is all in your verified petition. Is that right?
Well, and whatever comes out today, but yes.
Okay.
And so,
I mean, are you going to present evidence or is it just going to be the verified petition that you've presented? So tell me what you're seeking to do here today, other than make the argument you've already made.
well, if they present evidence, then I certainly want to be able to cross-examine if they have that.
Okay, I think they have filed a verified motion to dismiss, and I assume you've seen that.
I have, but it's not right.
Okay, so the ripeness will be when?
14 days under local rule 8.
So SB 40 claims that I have to render a decision after this hearing within 7 days, or you get whatever you want in your request for relief, right?
Correct.
And so basically, if I don't jump to and get a decision, you just win by default, regardless of the merits of this case. Is that your understanding?
That's what the legislature said.
Okay. Do you think that's constitutional?
I do.
Okay.
I mean, I listened to your arguments in the Shawnee mission. I understand your position. But look,
You'll understand my position a lot strongly when I issue the order that I have coming out here today in that same case. I've invited the Attorney General to intervene in that matter because I believe it's unconstitutional. Telling a judge, having a judicial go that if we don't jump to and issue an order within 7 days when these things are being repeatedly filed, that the plaintiff automatically wins. I don't know of any jurisprudence anywhere where a legislature declares a winner in advance if the judge doesn't do his or her job immediately. Are you aware of any case that allows for that?
well, I think I have a statute, the Kansas SLAP statute, which you file a motion to strike. The legislature said all bets off. You got to hold a hearing within 30 days, no discovery, no nothing. They do that all the time, Judge. And that's the distinction. When they create a cause of action, they can determine, just like they do in the rules of procedure, they have statutes and they can set a timeline. They can shift the burdens. They do that. And so that's what they've done.
You think that aligns with due process? That the school district here or the governor's office or a city council or the community colleges, they automatically lose if I get sick, I die, I can't get to this because I have 4 or 5 of these cases I have to deal with all at once. If I don't get to it immediately and they're complex, you automatically win no matter how wild the accusations for relief are.
Well,
is that your theory of due process?
No, because due process says, look, everybody's here. They had a chance. SB 40 says they had one chance to avoid litigation. They eschewed that. So now that qualifies me. That was my entry fee to get here before you. All right, you have 72 hours. Your own local rule, which you haven't asked me about, but your own local administrative order says, hey, sounds fair. You have to file a response within 24 hours. That's not in SB 40, but that's what a chief judge said. All right, so that's the rules you all set up. And all right, so now you have to have this hearing within 72 hours. You have required notice. They're all here. Due process, they'll have an opportunity to be heard. Now, the process then, the 7 days, which is what you're referring to, that's the deadline.
All right, So you want me to withhold ruling on a motion to dismiss for 14 days, but I have to make a ruling on your decision within 7 days. Is that how it works?
It will work that way because your administrative order did not require them to file a motion to dismiss. It's just file a response. Now, but
Now, let's be clear about something. Administrative order simply sets out the rules of the game so that everybody knows what they're supposed to file. It hasn't been tested on any issues in this case as it relates to constitutionality of D1 that declares a defaulted ruling. It hasn't been tested. By the way, the Supreme Court found the legislature when they tried to do this to the Kansas Supreme Court and tried to make them jump to and issue their decision, said, you don't get to do that. We're an independent branch of government. Legislature, you don't get to tell judges how fast to decide their cases so that you can appeal to whatever constituency that says, look what we did for you.
no, and I get it. I mean, I understand your angst, Judge, and I really do. But here's what I'm saying. That your case that you just cited is not a statutorily created cause of action. They were just fussing with you all about how timely decisions did or didn't come in.
It was a statute.
Well,
It was a statute that said, Chief Justice, if the parties get together and they don't think you've got your job done, go to every single justice and say, would you please hurry it up? And then get back to us and tell us when you're going to do your job. That's essentially what this is.
I get it, but this is like the SLAPP statute. This is a cause of action they created, a private cause of action. And so they define the contours, they define the burdens, they define timing. And I think they're entitled to do that. Now, that is, and look, nobody's questioning the Kansas legislature. They clearly putting the boards behind the 8 ball. They clearly altered the rules of the game. They did it, right? And so, and they did it they wanted it solved right now. And so they set out this process. That's what they did. Now, I understand you have a constitutional issue problem about it. You're going to issue your ruling, but the Kansas Supreme Court issued their administrative order. I think that prevails over your local rule. In fact, I don't think you had any authority to come up with your administrative rule, but that's neither here nor there. I don't think it's.
Are you saying there's a conflict between our local rule and the Supreme Court rule?
I'm saying SB 40 doesn't authorize district courts to come up with their own emergency rules. That would be.
Well, it doesn't say we can't.
Well, but here's the rule on that is we say the Supreme Court can by exclusion. That means who can. Under that idea, you got multiple districts out there that would be the tail that wags the Supreme Court dog. And I don't think it's authorized. I think they authorized the Supreme Court to do a rule. They made an administrative order, and I think that is it. Now,
well, I assume you've read the Supreme Court rule.
The administrative order, yes, sir.
Okay, and it specifically refers to local district court rules, doesn't it?
It does. It says anything in conflict, this takes precedent.
Well, it says more than that. It mentions other rules. So it anticipates that there may be other rules that controlled. I mean, Johnson County is an urban district. It's got a lot more people. It's got a lot more school districts, a lot of cities, a lot more people. It's also fielded more of these SB 40 cases than any other district, I would guess. And consequently, it needs to have some form of procedure for what is a decidedly vague act. SB 40 is very vague. The one thing it does, it authorizes a civil action. And a civil action under KSA 202 includes this kind of case where the rules of civil procedure apply. And if the rules of civil procedure apply, that means the parties, the defendants, get to file a motion to dismiss. Now, you're correct. Under our local rule, since there's been no definition otherwise, parties get a minimum period of time of 14 days to respond, and you're welcome to respond to the motion to dismiss. But this case shouldn't be held hostage on the ruling on the motion to dismiss simply because you think you get to preempt it with a 7-day ruling under SB 40. Now, we need to come to some conclusion on that issue before we move on, because if the district wants to be heard on their motion to dismiss, there may be a truncated version of the response as well.
Well, I don't think it's relevant to your inquiry today. The SB 40 statute simply says, you take our petition, you have one analysis. Is their policy narrowly tailored? Is it the least restrictive means? End of story, end of analysis. So you don't need to, in fact, it's not before the court today. They can make arguments about why it's narrowly tailored in the least restrictive means. That's the only issue before the court today. Now, you say, well, they filed a motion to dismiss. I don't think it's contemplated under SB 40. Look, Supreme Court Rule 133 says I get 7 days. So I don't think that.
Supreme Court Rule 166 says I get 30 days to decide a motion.
Well,
But you're saying,
I get it.
Mr. Baker, that the Supreme Court's administrative authority over the courts could be trumped by the legislature in this case. Is that right?
It is in that certain extent. So you've got some.
Do you think the defendant in this case deserves the same right to respond as somebody who's accused of domestic abuse? Because
They are here.
we allow in protection from abuse cases, people a minimum of 21 days to respond. And yet the district here doesn't deserve even that kind of time frame. Is that what you're telling me?
No, I'm not telling you that. They're here today. They're going to be heard. So they have the opportunity. But here's the point. I mean, we're not going to agree, but there are some of these rules that are not going to apply. 6256, summary judgment, will never apply in SB 40. Rules of discovery, not going to apply. So, all right. So we filed a petition. They didn't give the grievance. It's a denial by any other name. We've satisfied the condition for an SB 40 civil suit. We filed it within 30 days of the policy. We've got standing. We have a grievance. We set it forth in petition. The essence of that is that they have said that they're going to highly encourage Terry to disregard her religious beliefs. They're going to highly encourage her. And you say, well, it's not likely. Well, that's not what they say. So it is there. And if they want to modify that and put in Terry Baker, this doesn't apply to Terry Baker and her son, I'm all for it. But they not narrowly tailored that. Now,
So that would end this case if they said, you know what, we're not going to talk to your son. We're not going to talk to your wife about encouraging them to wear a mask.
No, it'll end it when they put it in the policy. So if they set that out in a policy and say, Ms. Baker, we're not going to highly encourage you to go against your religion, we're not going to do any of those things. If all they said is, we're not going to highly encourage anybody if it's against your religion, if it's medically contravened, or if it's interferes with the learning process of your son. Man.
All right. So are you asking for them to change their policy for one person to say that the one person is not going to have to be told to not wear a mask? Are you saying they need to change it for the entire district, or you won't be satisfied?
No, I'm not saying for the entire district. This is an as-applied challenge. The grievance is personal to Terry and her son. So I can't, this isn't a class action. I don't have standing to say dismiss it as to all the other parents. But as to these plaintiffs, then you can make a ruling to say that that policy as applied to them is not narrowly tailored, and it has to be narrowly tailored. Same way with, there's a lesser restrictive way as applied to Terry and her son to enforce this highly encouragement, and you can rule that. So that would only be something that applies to these plaintiffs. The rest of it goes on. If there are any other parents out there that want to grieve this, then they certainly can do that within the 30 days. Now, that's what we're asking now. I heard, and
just to be clear, can you, and I know you've got a long, I don't even think you put the word petition on top of your pleading, so it looked to me like it was kind of filed in haste, but can you tell me exactly the phrase for relief that you're asking for in this case?
Well, we want the this as applied to the plaintiffs to be narrowly tailored. We want it not to be enforced as against them. And under SB 40, you can issue an injunction under that. You can declare that as applied to Terry and her son, it can be more narrowly fashioned. It's not the least restrictive meaning, therefore it cannot be applied as to them. That
Okay,
would be the relief.
that's it.
That would under SB 40.
Okay, so, and just so it's clear to anyone who's listening who hasn't gotten into the weeds on SB 40, the paragraph that you're referring to is D1, I believe, that basically says that there's a different standard for school districts than there are for local units of government. Local units of government show that you have to be substantially burdened by whatever's proposed by the governmental entity. With school districts, they have a different rule apparently, and the different rule is they have to show that the policy is narrowly tailored to use the least restrictive means. Do you agree?
Yes, because they've automatically said the strict scrutiny applies. So they jumped through that and just said it automatically applies. And here's your analysis, and here's what you have to determine. What the defendants have said in the past is it's not as applied, that you have to throw out the whole policy. That's not what we're asking for. We don't have standing for that. We simply ask as applied to these plaintiffs. The other issue that comes up related to this, Judge, is, of course, is this a policy? Is this a COVID-19 policy? They say at the bottom, look for more information about, quote, mitigation efforts. I mean, clearly, the fully vaccinated means you got to get a COVID-19 vaccination. That has everything to do with the pandemic and the wearing of masks. They're going to continue to highly encourage it, at least to those who are not fully vaccinated. So how that plays out, they've simply given themselves a license to do whatever they want to do, to highly encourage. And they also set out the idea that there's going to be more mitigation efforts. But pertinent to that is this idea that it is a mitigation effort. So this has everything to do, I think, with their goal of hindering the spread of COVID-19. That has everything to do with the emergency in the state of Kansas. You have to say whether or not that is a policy as defined under SB 40, or an action or an order. It is, I contend. And with that, then, I will also say this. Now, I heard you talk about remand. I don't think you're sitting in judicial review. I don't think you're an appellate court. You're a court with original jurisdiction. And that is vested. There's no other tribunal to remand this back to. I'm not asking at this point. We've already done everything we need to get the relief from you. I'm not asking for a hearing. I don't need that. I'm already paid that ticket. I'm here. So to say that you're going to remand it back and say, hey, give this guy, give him a hearing, that what do? Divest yourself of subject matter jurisdiction? Then what happens? I got to file another lawsuit?
I'm sorry, did I say I was thinking about remanding this matter?
Hopefully.
Are you reacting to some other hearing?
I'm reacting to your statements in the Shawnee mission where they didn't get a hearing and you talked about remanding. So I just anticipate.
Well, and the reason for that was they asked for a hearing and the superintendent in that case said, you're not getting a hearing because there's nothing to hear. There's no policy.
That's what happened here. That's what happened here.
Okay.
So you mentioned remand. I'm going to urge you, that's not in the wheelhouse. You've got original jurisdiction. This isn't a judicial review act. I mean, if you thought about that, what would be the scope of review? If you're sitting as judicial review, are you going to look at substantial evidence?
I think the reason for that kind of thing can occur, and the reason that we have judicial review and potential remand, and we do sit as an appellate court, are in a lot of cases. The cases like unemployment reviews.
No, I get that.
DUI cases. Lots of times the people that are bringing these things to our doorsteps, unlike you, a trained attorney, don't always know what they're doing. Very often will fail to elicit the facts that may be necessary to decide the case fairly. And sometimes we have to send it back to say, hey, the record's not clear on this, develop it, get this taken care of, and then come back here.
No, I
You're
get
saying
all
don't
that.
go there.
Go, I'm just saying this is a de novo. You have original jurisdiction. There's nowhere else to send. I'm not going to get relief from the board. They're not going to make a declaratory judgment. They're not going to give themselves an injunction. They're not going to do anything. You're the tribunal that the SB 40 says that you will grant the relief stated in the petition, not that I requested, but in the petition. So it's clearly saying that we paid the ticket to get here. We've satisfied all the elements. So you've got the jurisdiction, you can so rule. I will say this too, Judge, is that this policy of fully vaccinated, the schools are limited in what they can say who can and who can't be vaccinated. That's determined by the Secretary of the Kansas Department of Health and Environment. They give the list of vaccines that a school is required to enforce. In fact, they have a couple of recommendations, but they don't allow schools to come up with their own vaccinations, namely COVID-19. The Secretary is not required or even recommended COVID-19 as a required vaccine for school enrollment. You've got a school over here, though, is saying we want you to be COVID-19 vaccine injected, even though it's not FDA approved. It's still experimental. It's still being given on an emergency basis. So I don't think that it's even proper for them to even parlay this idea of fully vaccinated. And this is sent out with the idea that parents are going to rely on this. And it's going to be an encouragement to them to go out and get this COVID-19 vaccine. Now, I don't think they ought to be in that business. I think that's reserved for the Secretary of KDHE. Otherwise, you're going to have all these school districts coming up with all kinds of ideas. So that's the petition. I've set out how I think you can grant the relief and as applied to these plaintiffs, as applied, you can say that doesn't apply. I will enjoin you from applying that policy to these two plaintiffs.
All right. Mr. Hatley?
Thank you, Your Honor. First of all, I want to state that we share the court's constitutional concerns over SB 40. We actually raised that in the motion we filed in the previous case that's now in federal court, although on different grounds. I didn't feel that we necessarily had standing to speak for the judiciary, but we did certainly raise constitutional issues. I would add, and we didn't raise them here because we didn't believe that they were necessary for the adjudication of the case. We believe this case is fairly easy to decide. However, and I don't think the court's inclined to agree with Mr. Baker's arguments about the timeline and the fact that we cannot move to dismiss this, and yet the court has to rule within 7 days. If that were to be a serious position, I think that would raise serious constitutional due process problems as to the school district and the other defendants in this case. But I want to move to the merits of this and just try to get this out very clearly. Blue Valley's mask mandate expired effective June 1. That was made very clear in the communication that went out to the community on May 28th, and it was made crystal clear to Terry Baker, the plaintiff, in the email that we attached as Exhibit H to our response. That was from Ms. Hillman, making it very clear masks are not required any longer in Blue Valley schools. That's the first fact. There is no mask mandate in Blue Valley. Here's the second fact. Blue Valley is not mandating that students receive a COVID vaccine as a condition for attending school, and nor could it, as to Silas Baker. He's 6 or 7 years old, somewhere in that age range. The vaccine's not even been approved for administration to children under 12. So we're not going to be asking him or even encouraging him or his mother to get him vaccinated. One other fact, Mr. Baker didn't answer this question, I think very, very plainly for the court. Silas is not attending Blue Valley schools. He's enrolled. His status as an attendee or a non-attendee is tied up in one of the other lawsuits they filed. I think it may be in the Shawnee County case right now. But be that as it may, he has not been presented for any services by the Blue Valley School District this year, and he is not in summer school. Now, the Bakers know that the district doesn't have a mask mandate. They know the district hasn't mandated COVID vaccines, and yet they filed another lawsuit against Blue Valley. They're tilting at windmills that exist only in their own imagination. Your Honor, we believe this is an abusive lawsuit, one in a series. It has no factual basis, and we'll deal with the rest of the suit down the road. We're here today to talk only about the SB 40 claims, which we do have a right to respond to. The document we filed was a response to the SB 40 claims. We said it's a motion to dismiss. The court can treat that as it wishes from a procedural standpoint, but it's one and the same as far as we're concerned. Just by way of background, Blue Valley's board adopted the navigating change guidelines in August of 2020. And those guidelines, the navigating change document included a mask mandate. Blue Valley has enforced that mask mandate up to the end of the school year and has provided individualized exemptions when people come forward with sufficient evidence to support them. But then on May 28th, Blue Valley announced that per its terms, navigating change was expiring at the end of the school year. Effective June 1, it was lifting the mask mandate. It did still highly encourage unvaccinated persons to wear masks, but it did not require them. It is not requiring them. And this is simply consistent with what a lot of other school districts in this area have done. That's reflecting the rollout of the vaccine and the drop in case rates. The Board of Education for Blue Valley has taken no action to reinstate a mask mandate. That's not on the agenda, to my knowledge. If the board felt that one needed to be reenacted, the board could have called a special meeting and held it for that purpose. It's not done that. There is no mask mandate in Blue Valley today. Despite all this, Terry Baker.
Let me just interrupt you, Mr. Hatley, just for a moment.
Sure.
You know, we had the same issue arise in the Butler case that I'm about ready to issue my order on. And there, the school superintendent basically wrote an email that says, yeah, we're not going to give you a hearing because there's nothing to hear. We don't have a new policy. It's the same one we've had for 11 months now. So there's no hearing. And in that case, the parents, at least one of them, had all the exemptions she could possibly want. She was complaining about the exemptions, saying, well, my kid feels bad now because they go to school, they don't have a mask on, and then they're socially distanced, and that makes them feel ostracized, et cetera. And so they started wearing a mask. So the harm was, you're making my kid wear a mask because they don't want to be socially ostracized. But the real question there, and the one that was raised by the Shawnee Mission School District, was that this wasn't an action order or decision by the board because the superintendent was doing something. And of course, the superintendent is the executive for the school board and acts on their behalf as their agent. So this COVID announcement, the update, as you put it, was that authorized by the Board of Education, or who's issuing the update?
Your Honor, I can answer that question very plainly. It's authorized because navigating change is interpreted by Blue Valley to include an expiration at the end of the school year. So all the superintendent was doing was pointing out that this document is expiring at the end of the school year. That's what the school board approved back in August.
All right, so in this instance, like the Shawnee Mission District case, it's the school superintendent who's sending this update out to the patrons.
Simply announcing a fact that the policy that the board adopted in August expired by its terms at the end of the school year.
Okay. But he apparently, under this policy, is there something with the state education department that says we're still encouraging masks, or is this something he came up with on his own?
Your Honor, I'm a little leery to comment on what Shawnee Mission did because I'm not involved.
No, I'm
in
talking
this
about
case.
your superintendent.
Oh,
this case.
yeah, Dr. Tanya Merrigan. Your Honor, I think she was relying solely upon the authority granted by the Blue Valley Board of Education. I don't believe the State Board of Education's actions or inactions have had any impact on that. I think under SB 40, it's clear that if there's to be a policy, it has to be adopted by the local Board of Education. Here, and what happened here, there was a previous case, Your Honor, before Judge Winnell, where Judge Winnell determined that SB 40 doesn't apply retroactively,
Right.
because Blue Valley was adopted back in August, and he said that's a SB 40 is a change in the substantive law. Blue Valley's taken no action in the intervening time that brings it within the scope of SB 40. So that's in essence what we have here. But all Dr. Merrigan did was simply announce to the community that the navigating change document had expired. That was a reasonable interpretation of that document based upon the excerpts that we provided to the court. And as I indicated, the Board of Education always has the authority, if it wishes, to call a special meeting and say, Superintendent, we believe you overstepped your bounds here. The Board of Education has not done that in this case.
Okay, so I'm just curious, not that everybody here is willing to try to entertain something that isn't a litigation position, but is the district willing to just tell Mr. Baker, guess what? We're not going to tell your wife or your child. If your child does become enrolled in August, we're not going to encourage either of them to do anything with regard to masks or vaccines or whatever.
Your Honor, I'll tell you why, in my view, I'd be reluctant to agree to that. And I think it's grounded in practicalities. The district sends out district-wide communications frequently, and it tries to include all the parents of all the students on those communications. If it were to send out a communication, if the court were to enter an order to that effect, and the district then sent out a district-wide communication, and it happens to get to Ms. Baker, guess what? Given the litigious nature of her, we're going to be right back in front of this court, this time possibly on a contempt motion. So, Your Honor, we're not prepared to do that. I also believe, and we cited to this case in our brief under the government speech doctrine, the government has a right to speak. It has a right to state its position on matters of controversy. And if people don't like that position, they can come back with more speech. But simply speaking, I don't believe, or encouraging someone to wear a mask certainly does not violate any rights. There's no restriction imposed. It's not even within the scope of SB 40, I believe, because it requires an affirmative action policy or order of the Board of Education in reaction to a state of emergency declaration. The other thing I'd point out, Your Honor, in response to your question is the state of emergency in Kansas is scheduled to expire a week from today. And, you know, we can try to read the tea leaves, but I think based on the comments from the Legislative Coordinating Council, it's probably not going to be extended. And if it's not extended, SB 40 goes out the door because it's predicated upon the existence of a state of emergency. So we would be very reluctant to have the court enter an order that says we can't encourage someone to wear a mask based upon a law that may be of no effect a week from today when he's not attending school now, showing no signs of attending, and at the earliest would show up in August whenever school resumes. Your Honor, the only other point I want to make on this is that, as the court pointed out, the standard here is this the least restrictive means necessary to accomplish the interests that the district is trying to advance? And as we pointed out in our brief, Your Honor, Blue Valley has no restrictions anymore. There can be nothing less restrictive than no restrictions. So the substantive standard for SB 40 is not satisfied here either. So, Your Honor, we simply do not believe that there is an SB 40 claim here. There was no board action policy or order that triggered SB 40 rights. So Ms. Baker was not entitled to a hearing.
You know, you raise an interesting question. You know, I reviewed, probably was your motion to dismiss in the case that Judge Winnell was involved with, and I reviewed his order. And obviously I reviewed the concept of retroactivity and substantive rights. what is the substantive right of SB 40? Because is it, you make a decision, school board, and you have obviously constitutional standing to do certain things to protect the patrons in schools, students, et cetera. Is it a de novo review? What is it? I mean, is it just like we just start over again? Am I supposed to defer to the school district? I mean, am I supposed to just come up with my own? I mean, SB 40 is very vague in that regard. It just says, make sure it's narrowly tailored and make sure it's the least, it's the most limited version of what you have to do, presumably to restrain the pandemic so that you're not trampling on somebody's rights.
Sure.
What's your view of that?
Well, Your Honor, actually, despite Mr. Baker's negative words about this court's administrative order, I think this court's administrative order touched on this because it requires an SB 40 plaintiff to articulate in their petition how they believe the public body's orders could be less restrictive. It actually does place some burden on the plaintiff to come up with a better idea than the one that the school district, the city council, the county commission have come up with. And then, you know, the court in that situation can look at that and make a determination. But I think part of the issue here is that SB 40, because of its short procedural timelines, you know, those sorts of things do raise constitutional concerns because, you know, the folks involved in this are looking out for the interest of everyone in the school district. And sometimes that does require someone else's interest to be restricted. So I don't know that we've ever gotten to a point in these cases where we've actually had to decide what that standard is. But I think the fact this court's administrative order places some onus on a plaintiff to articulate a less restrictive method to accomplish that objective. I think we can all, I would hope we can all agree, people on all sides of this issue, that reducing or eliminating the spread of COVID is a worthy governmental objective. So what we're trying to figure out here is what is the least restrictive way to do that. And I think whenever the pandemic was raging, I know folks differ with this, but the consensus, at least among the reputable scientific community, was that masks were a very effective way to do that, combined with social distancing. And obviously, hopefully, we're beyond that point. Seems that we are, by virtue of the fact that Blue Valley's lifted its mask mandate. I think the intent is to come back to school in person in the fall. And and with the state of emergency expiring next week, a lot of these are going to be interesting academic points, but I don't think they're going to be.
Actually, I need to ask you about that. Section 5 of SB 40, specifically the last sentence of paragraph A, says, in reference to the emergency, that it was continued in existence from March 12, 2020 to May 28th, 2021. Didn't the emergency expire already?
Your Honor, my understanding is that the Legislative Coordinating Council did extend it one more time to June 15. I think because we were thinking that it would expire around that time too, and we're contemplating that happening. But we were obviously closely following what was going on in Topeka, and it did appear there were discussions. I think a lot of it had to do with federal money drying up if they let it expire when they were originally going to. So I'm pretty sure it got extended to June 15, but the LCC said we're not going any further.
Well, but according to the Senate Bill number 40, which you attached to your motion, and we've looked at earlier, it shows a strikeout of March 31, and then it shows a italicized version of May 28th, 2021. Isn't that what was enrolled in the Kansas Register and became the law? Which means it's over.
If it is over, then this whole thing's moot. I've been operating under the assumption it was June 15 based on my understanding of what the LCC did, because I think there was some authority given to the LCC to either override the governor's extension or not. And I believe the LCC went along with the June 15 expiration date. But if I'm wrong, then clearly there's no case to decide because SB 40 is of no further effect.
Mr. Baker, do you know?
I don't.
I mean, I'm looking at the law here. Unless the law has changed, it was over on the 28th of March. And the reason I bring that up is the school district's motion in the Shawnee Mission School District case argued the emergency was gone and effectively argued the same thing you're arguing, and there was no extension of any policy. It just simply expired, and there's no threat at this point to children who are not even in school. I mean, we didn't even know what the policy is going to be come reopening of school. So right now, according to what I can see, unless either party can provide me any authority, the emergency's gone. There's nothing to talk about with regard to any emergencies.
Your Honor, I'm just doing here trying to find doing a search here to see, but I know when I was following this, it sure seemed that because it was extended to May 28. I'm looking here at a release from the governor's office on March 24, reflecting that it was extended to May 28. And I recall that there was a lot of discussion about, okay, this is getting ready to expire, and then the coordinating council went ahead and let it run through. Actually, I'm looking here, Your Honor. I understand this is not an authoritative source, but I'm looking at an article on the KSNT.com website, which I believe is a Topeka television station, saying that the legislative leaders voted on Friday, which would have been May 28, to extend the state of emergency through June 15, 2021. It was a 6-2 vote. And that's what we were basing our argument on, that the state of emergency still is in effect.
Okay. So June 15th, it's all over with, at
Right.
least according to the TV station, but according to the law that you've attached, it was gone as of the 28th.
Yeah, Your Honor, I honestly had not dug into the session law or the Kansas Register to see exactly how that was accomplished.
And
But,
interestingly enough, subsection C, which is italicized showing it was added, basically says, notwithstanding any other provision of the law to the contrary, all executive orders issued during the state of disaster emergency ratified and continuing in existence pursuant to this section related to blah, 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 are hereby revoked on March 31st, 2020, and shall be null and void. So essentially, they kneecapped the governor's ability to announce any kind of emergency. He said it's over on March 31st, but the Legislative Coordinating Council, just to keep the federal monies flowing, decided to extend it to June 15th, even though the law says it's done by May 28th. And I'm supposed to adjudicate this under an emergency issue.
I'm searching right now the Kansas Register around that time to see if there's anything in there, because my understanding, Your Honor, is that the legislature did basically delegate to the LCC the authority to go along with extensions whenever the legislature was not in session. I don't believe the legislature was in session then. So that was the 6-2 vote of the coordinating council.
May I offer some assistance?
All right, go ahead and identify yourself, counsel.
Stephanie Lovett Bowman, also on behalf of the defendants. I was just pulling up the law to try to be of assistance. I think section 4B3 is where we obtained our understanding that the legislative coordinating council could extend the state of disaster emergency.
Okay,
When the legislature was not in session.
but then that begs the question, did they? So
Right.
you tell me you think they voted to do that, but bottom line is, whether it's the 28th of May or whether it's June 15th, Mr. Baker's son will not be in school at the time of the expiration of the emergency, one way or the other.
That is correct.
Okay. All right, go ahead and wrap up your argument, Mr. Hatley.
Yes, Your Honor, we simply do not believe there is a valid basis for any release under SB 40. There is no action or policy order of the school district, the Board of Education. Navigating change expired by its terms. All the superintendent did was make the announcement to that effect, and included in that announcement the implications of the expiration of navigating change. To be clear, there is no mask mandate in Blue Valley. Blue Valley is not mandating students to receive a COVID-19 vaccine as a condition of attending school.
All right, Mr. Baker, would you like to reply?
Thank you, Your Honor. The action or order of the Blue Valley is not about the mask. It's about the highly encouraging in the future. And that is that they'll do that in contravention of a parent's religious beliefs or the medical condition of the child or the learning disabilities. It's that provision that they say they will do, highly encourage. That's the grievance. And we don't want that enforced now, as against Terry and her son. And that can take on many forms, highly encourage, will highly encourage. There's no real limits there. And, but I understand your position. You say that's going to expire June 15th. It may not, I don't know. But we have satisfied the standing requirements. And at this point, have they proven that it's narrowly tailored or the least restrictive? No, they have not, because they can accommodate a medical exemption, which they can do, to this highly encouraged thing, when they can give a religious accommodation. They can also give a learning disability accommodation. They can narrowly tailor what they are promoting in that regard, but they have not done that. This is a one size fits all. So they haven't met their burden. And we ask that you grant the relief that we requested in the petition, that policy not apply to Terry and her son.
Okay. Anything further from anybody?
Your Honor, I know you have a period of time under SB 40, assuming it's constitutional, to issue a ruling in this case. And if this question of the expiration of the state of emergency is material, we can look into that and provide the court with a supplemental brief on that very quickly once we dive into the details of that. And I was looking also to see if the Legislative Coordinating Council had any minutes shedding light on that, short of my news story, and couldn't find any immediately.
Well, from the embedded notice that Mr. Baker put in his petition, where it says update on COVID policy on page 5 of his petition, that alone says that the Kansas Department of Education navigating change adopted by Blue Valley Board of Education August 18, 2020 expires May 28, 2021. So it's really not material at this point whether or not the Legislative Coordinating Council, seeking federal funds or trying not to turn off the spigot of federal money, has declared the emergency over, or whether or not the school district has already given by SB 40 the ability to make determinations in this area. And according to this, it, as well as section 5 of the 5C of SB 40, all mention that magic date of May 28. So even if it's extended, the fact of the matter is the school district has determined that it is not extending any emergency or any policy regarding any emergency. So what it does is it winnows this case down to whether or not Mr. Baker's argument that somehow you're highly encouraging is a policy, or whether or not that's something that requires it to be narrowly construed or tailored for the most limited effect. So at this point, I don't see any point in giving anybody additional time. Mr. Baker's asking for the relief right now. He's not willing to say that his time to respond to the motion, which is 14 days under Rule 8 of the local rules. He's not willing to wait until that occurs for me to make a ruling. And even though I could shorten the time, because I believe that under 6020 or 202B, this is a civil action and the rules of civil procedure apply. And the fact that we have a local rule on that, because many times people didn't know what the time frame was, doesn't mean that we can't shorten the time, et cetera. Just like the time to answer or respond has been shortened by the legislature. This has become a truncated emergent proceeding. And Mr. Baker says there's not even a hearing that he needed to request, that he paid the ticket and he wants a ruling, and he's going to get it. And the ruling is, I don't find this to be a policy, period. It's basically an information piece by the district that says this is all over. This is what we think will be the way things are going to be. Nobody is being told what they have to do. I don't find that there's anything suggestive about this that impinges upon anybody's religious rights or ability to parent their children or be pressured to do anything. It simply says masks will not be mandated, but they'll be encouraged. And I suspect as the vaccination rates in this country continue to increase up to 60, 70% by July, by the time that August rolls around, there'll be all sorts of informational things about what school districts or governmental entities or employers or private employers want to encourage people. And nothing about that in any way undermines somebody's religious rights or their ability to parent their children. I don't see any harm at this point. As far as I can see, I don't accept the idea that there's a prospective future injury, and I don't accept that this is a policy. So for all the foregoing reasons, the court finds that this would be count 4, I believe.
Yes.
Count 4 should be dismissed, and I don't find any basis for further hearings on that count. So you can, so we get a decision within 7 days of this hearing, Mr. Hatley. I'm going to instruct you under Supreme Court Rule 170 to memorialize the court's determination and submit it as soon as you can. Anything else?
Nothing from the defendants.
Anything else, Mr. Baker?
No, Your Honor, other than to say that I don't think I have the ability to alter the SB 40 timelines, but I understand your ruling.
Well, and I will tell you, both of you, and since I know, Mr. Baker, you're a student of the law and you pay attention to a lot of things and you're up on a lot of constitutional issues, my ruling in the Butler case will be issued today. It's roughly 20 pages. It addresses the constitutionality of SB 40 in various respects. It doesn't finalize the order because, as you both know, I cannot declare a statute unconstitutional absent giving the Attorney General, in this case, Attorney General Schmidt, an opportunity to intervene. But I'm going to notify him as part of that order that if he wishes to intervene before I finalize my order, he's welcome to do so. But I think there's some serious issues in this case with the, what, as I put it, the judicial goad of get it done in 7 days or else the plaintiff wins. I just think that's an atrocious form of leverage that the legislature puts against any party. And I don't think anybody has a right to say you don't even get due process until we decide, until the judge decides the case. I mean, you guys could knock yourselves out and argue this case and all that, and I could get killed by a car and one of my colleagues wouldn't be able to respond within 7 days. And according to SB 40, you win. You win, no matter what the merits. You may say, I want to drag the superintendent out in the street by horse and carriage and drag them through the streets. I want to humiliate everybody in the school board. But guess what? I get to do that if they don't respond or the judge doesn't issue a decision in 7 days. Yeah, I know it's a little wild.
Yeah, let the record reflect. I didn't ask for any of those things, Judge, but I do. But I do look forward to reading. I know.
Let the record reflect that your humor is intact, Mr. Baker.
There you go.
All right. So I'll be done. Anything else?
Thank you, Your Honor. No.
All right.
Thank you.
We'll be in
Thank you.
recess. Thank you.